Can you hear me?
I can hear you. Can you hear me?
Yep, excellent.
Perfect.
I'm just posting up a link with some content to PSP from CA4IT. So if anyone has any more information they'd like to look at, that's a great place to grab some information. So I think that there's lots to talk about. It's been a while since I've had a chat on personal service business. I'm not sure where you want to start, Wendy, and I know many of the callers might be familiar with it, but maybe we should start with a definition of what PSP is.
Yeah, that's where I thought we would start today. Is just to take, like, what is a personal service business, and what's the risk to a personal service being classified as a personal service business?
Yeah, so basically, a personal service business is an independent contractor. I'm going to put this in layman's terms. That's determined by CRA to be an employee of the end client rather than a true independent contractor. And there's a whole bunch of specific language and literature around that defines what CRA calls a personal service business. I'm not going to bother going to the details of that. If anyone wants more information, again, I'm happy to go offline on that. But basically, it's when you're determined to be an employee of your end client rather than an independent contractor. And the ramifications of this are fairly significant because what happens is you lose a lot of the deductions that you're able to have as an independent contractor. And any of the money that's left inside your corporation after these limited deductions is now taxed at a much higher rate than what you'd be eligible for if you were considered a small business here in Canada.
Okay, and so how would people know if they've been declared a personal service business? Is this something that you get notification from the CRA? Is it something that you may have inadvertently declared yourself as a personal service business? Or how does that process go about? How would someone know if either they've been impacted or not been impacted?
Well, certainly you'll be notified by CRA if they are assessing you to be a personal service business. And there was quite a large project that went on back in 2010 where they went back through and reassessed quite a few people. In addition, they have also changed the corporate tax returns so that you can self-assess as a personal service business, which is a very high risk because that's a legal document. And once you declare yourself as a personal service business, there's no real coming back from that. And this is something you've got to be very, very careful of. The most dangerous thing you can do is file your own corporate tax return or work with a professional who's not experienced or knowledgeable in personal service business risk. So if you're an independent contractor, have a conversation with your accountant and make sure that they're informed and up to date on what's been going on. And, one of the things that has happened in the last couple of years is this project that was started back in 2010, which was a big push by the government to reassess quite a few people as independent contractors. And there was this special survey that went out, and unfortunately quite a few people responded to that survey without having enough knowledge on how to respond, on what the issues are as far as what language they can and can't use. And they reassessed quite a few people that they determined to be, that CRA determined to be PSB. And while this project was going on, CRA had a mandate that if anyone was assessed as a PSB, that all auditors were to deny any appeals within the appeals process, and it was to go to tax court. As a result of that, the NACCB, which is the National Association of Computer Consulting Businesses, took a stand and said we need to defend the industry against this attack by CRA. And we hired Gowlings to represent about 16 of the IT professionals that we were aware of who'd been reassessed. And over the course of the last 4 years, Gowlings has been successful in defending all 16 of those cases. So not one of them was determined to be a PSB. And interesting enough, we had selected one case, which was the case called the Clinton Hamilton case, that we had hoped would be the landmark precedents that would be used to demonstrate to the courts and to CRA why the IT industry it was important to have independent consulting and have a contingent workforce, and to show independent contractors what was and what was not a personal service business. Unfortunately, CRA is a bit of the bullies in the playground, and when they know they're going to lose a fight, they back down. And what happened with this Clinton Hamilton case, even though it had been denied by all 3 levels of appeals within CRA, CRA's lawyers came back with a consent to judgment. And what that basically means is the case was not going to go to court and be seen by judges, and therefore could not be used as jurisprudence or what we could use to demonstrate to the independent contractor market how to act like an independent professional. Now, subsequently, a couple of cases did go to tax court. Of the 16, I think we had about 6 that went to tax court. Again, all 6 of them were fought and won by Gowlings, which just goes to show you that it's really important to have a knowledgeable professional in your corner who knows how to deal with this, because even though these people were assessed as personal service businesses and went through the entire appeals process and even went to tax court, that with a knowledgeable representative you could fight and win your case. And 3 of the 6 were won in tax court. 3 of them were actually lost at the first level. So basically what happens when you go to court, just like in the appeals process where you have 3 levels of appeals, within the court system you have effectively 3 levels of 3 opportunities to fight your battle, which is tax court, federal court of appeals, and Supreme Court of Canada. And the good news is that winning those 3 cases at the tax court level is actually, it was sad that we had to fight that fight the way we did, but it was good because we created some evidence and some jurisprudence. And if you go back over the 30-year history of personal service business, because this is not a new issue, very few cases had been fought and actually won at the tax court level. Most of them had to go through to the appeals. And in fact, that's what happened with the last 3 cases that were assessed at the tax court level to be personal service businesses. They went on and filed an appeal and won their appeals case. So like I said, all 16 cases represented by Gowlings fought and won by us. And in addition, what we've also done is we've been working closely, or the NACCB specifically has been working closely with the CRA to get some IT bulletins and some information out there. And there is a new information bulletin that's been put out by CRA with regards to CPP and EI departments. And basically it's an IT bulletin that says every case will be judged on its own merits, which is typical CRA language. They are effectively looking at the IT industry as being different from other industries and recognizing that the contingent workforce in IT operates very differently than other independent contractors. And it's not uncommon for a project, as any of us know who've been, touched the IT industry at all, it's not uncommon for projects to go well beyond the original scope. And it's not uncommon for people to be on a project for several years. And so they're looking at the IT industry finally with a little bit of new knowledge, thanks to the leaders at the NACCB. And they're recognizing that the independent contractor market is different for IT consultants, and they're not targeting them as much. Now, unfortunately, there has been some activity out west in the oil and gas sector. We haven't seen much in the IT sector here in Ontario, and we have some non-committal information from this area that basically says they're not actively targeting the IT community right now. That being said, the way the Income Tax Act is written, there is still risk out there that anyone could at any time be assessed as a personal service business. And our general high-level guidance is the key to defending yourself from this is, if you want to be treated like a business, you need to look and act like a business. And so, I put up that link to our homepage. We've got quite a bit of content because we have been fighting this issue for over 30 years on our website around personal service business. And we do have a sort of top 10 tips of ways to protect yourself, and everything from having a website, having a social media presence, having business cards. And like I say, the more you look and act like the business, the more you'll be treated like one.
So are those really the steps, Andrew, that people can take to avoid being declared a personal service business? Or is there other things in terms of how they engage as a contractor, with contract with the staffing agency, working through staffing agencies? Is there other things that people can do to ensure that they're not going to be deemed that way?
Well, we always recommend working through staffing agencies because of once upon a time, it created a barrier because there was an intermediary between the end client and the independent consultant. Unfortunately, CRA has been looking through that and treating the relationship as though it were direct, which in our opinion is completely unreasonable, but they have been doing that. However, even over and above that intermediary, the benefits that you're getting with a staffing agency is, you've got contracts that have been vetted by lawyers and accountants to eliminate PSV risk, because it's really easy for someone to go and grab a contract that was maybe originally intended for an employee and try and rework that for an independent contractor and really put themselves at a lot of risk, because your contract is really sort of the starting point. And it's the first thing that CRA is going to look at, because that's black and white, right? That's somewhere where they can really nail you to the wall. If you've got something in your contract that puts you at risk, you're at risk, period. There's not really any, or not much. There's always loopholes, but there's not much we can do.
So what are things that people should look for in a contract that they're signing that may, be something that might be a highlight for CRA? That they either might anything that's treating you like an employee. You really want to have a contract that treats you as an independent contractor, and really we want to get away as much as we can. And this is difficult in the evolving world of IT, where end clients want to put more and more demands on the independent consultants. But in an ideal world, I'd love to see a contract that was really clean and simple, and that basically had an early termination clause that didn't put any controls or restrictions on the independent contractor, but basically said if they were unhappy with the work for whatever reason, they could terminate without any penalties. And that's sort of the ideal contract, is it's an early termination. Right. So basically, they don't put any restrictions or controls over how you perform the work. But if they're unhappy with the way the work is performed, they can terminate the contract. And that's sort of the ideal. And I know it's not always easy to get to that ideal. But what we want to try and avoid is having things in there that indicate they control how you do the work. And what I can say is, even in this IT bulletin that CRA put out, they do recognize that within the IT industry there are certain requirements around security where they must put in certain levels of control that might, in a normal independent or normal work environment, consider you to be more of an employee. So there is some acceptance that there's some level of control that must be put in within IT departments, even when you're an independent contractor. But we really want to ideally get to a contract that is really straight, early termination. Right. So I know that leaves it really open, but every contract has to be reviewed by a lawyer and ideally an accountant as well. Yeah, I mean, obviously banks don't allow you to just take their data off-site. There's very strict rules about that, and in terms of how they have to control things. I mean, a lot of times we find we get comments from contractors about them having to accept risk as part of the contract. And our point of view on that is, you want to, as an independent contractor, accept some of the risk, because if we hold all the risk and you hold none, then you're not really operating as a business. It's a shared risk.
Yeah, and in fact, that's one of the definitions of what an independent contractor is that there's risk for profit or loss. If there's no risk for profit or loss, you really are an employee. And so you're absolutely right on that. That's one of the biggest criteria. And one of the other things that we often recommend is how you mitigate that risk is through insurance. And insurance is a great tool. And I know that there's organizations out there like LMS ProLink that work with staffing agencies to make this really affordable for independent contractors as well. And it mitigates the risk, which is great, but it also proves to the CRA that there is risk, because by definition, you wouldn't be paying for insurance if there wasn't risk
Right.
to mitigate. So it's, again, one of the
You've
things.
accepted the risk and you've insured against that risk.
Exactly. So there's ways to protect yourself against the risk, but in order to be a true independent contractor, you have to take on some risk, and how you mitigate that is up to you.
Yeah, I think there's maybe some misconceptions about how expensive insurance can be out there to mitigate the risk, and I think people should reach out to companies like LMS, because there are not crazy financial obligations to get the insurance that can help you mitigate against most risks that IT contractors are accepting.
Yeah, absolutely. I think it's people perceive it to be far more expensive than it is. I think, if I'm not mistaken, the plan that LMS has is less than $50 a month, and I think I don't want to quote any numbers. We'll have to put together another lab and get the guys from LMS on here to talk about that, because I think it's a really important aspect for independent contractors.
Okay, and then what criteria must a contractor meet in order to minimize that risk for PSB?
Well, we talked about the risk for profit or loss, and there are some criteria that were set out originally by the youve case. And again, you can go to our website to find out more information about the different criteria. But really, where people have been nailed to the wall is, obviously we talked about the contract earlier, but it's also conduct. And this is one of the areas where, when CRA was winning cases, that was the area that they were winning. And because if you're conducting yourself as an employee, you are in effect an employee regardless of your contract. And conduct is somewhat subjective, and it's really easy for people to put their foot in their mouth when it comes to understanding that. And one of the big ones I always use as an analogy is working a certain set of hours. Like if you're coming in and you're working 9 to 5, you might say, well, I'm abiding by the policies and procedures of the workplace. No, you're not. You happen to have your own policies and procedures that mirror those of your end client, so that you can be an effective independent consultant. Because you can imagine, if I were to hire a painter to paint my house, no one would argue that a painter is an independent contractor. But if he came in to paint my house at 4 in the morning, he wouldn't last very long. Just like if you were trying to do your job at 4 in the morning rather than when the business was conducting its core operations, you wouldn't be very effective, and you'd be terminated pretty quickly. But it's really easy to lose sight of how you are independent, and think that, well, I'm coming in and I'm sitting at a desk right next to an employee and I'm working the same hours as an employee. Well, you're doing that because that's how you're effective as an independent contractor, not because you're abiding by the same policies and procedures that employee in the next cubicle must abide by. So it's really important to understand that.
Okay, and obviously there's tool tests out there to determine whether or not you're an independent contractor or not that CRA use. Like one of those is like, do you bring your own equipment to work? In a lot of IT environments, that's not possible due to, again, the restrictions that they've placed on their security infrastructure. Some clients will allow you to bring your own device to work. Others will not. Some will allow you to connect in with your own mobile device. Others will not, but they still expect you to be responsive to their needs because you're on a critical project, whether that be as a project manager or as a developer meeting the needs. How do you go about protecting yourself when the bring your own device policy is not possible within an account, and that if that's how the CRA is going to look at those tool tests?
Well, first of all, we've been very successful in proving that the tools you bring to the job are the knowledge that you bring to the job rather than the physical tools. And like I said, in addition, there has been this updated information bulletin that acknowledges that IT is very different and has specific requirements around security and project management that make it different than traditional independent contracting. Keep in mind that a lot of the rules tests that were created over 30 years ago, primarily out of this original landmark case, which was the youve case, which really opened the door to independent contracting as we know it and understand it. And youve was not an IT company; it was a door installation company. So bringing your own tools when you're a tradesman is very different than what your tools are in the knowledge economy. So I think it's important to understand that difference. And that's why I say, while there are these tests out there, and you'll find lots of information on the web, you can Google it and they'll give you all the tests that are out there. It's much more complicated than that, unfortunately. And everyone will always tell you every case is judged on its own merits. And we have to look at the sum of all of the activities rather than any one individual test, whether you pass or fail that test. And even the courts have come to acknowledge that you may fail an individual test, but that does not in and of itself make you a personal service business. And that's one of the big misconceptions out there, I think.
Okay. So what are the possible tax penalties that I would face if I got reassessed as a personal service business?
They're significant.
Myself inadvertently as a personal service business.
They're really, really significant. And that's why another one of the analogies that I use for personal service business is it's kind of like a shark attack. Anyone who's ever heard me talk has heard me probably mention this before. But I call it a shark attack because when it happens, it's vicious and atrocious, and the impact is significant. You're going to lose literally an arm and a leg here. They're going to, as I say, disallow a lot of expenses, the majority of your expenses, which is a huge tax savings because every dollar that you have as a deductible expense as an independent contractor is income that you're not paying tax on, and that's a huge advantage in and of itself. The income splitting requirements are now going to be different, and the money that's taxed at the small business tax rate is now taxed at a significantly higher, over 3 times higher tax rate. So one of the great advantages of being an independent contractor is this idea of the small business deduction and being able to leave money inside of a separate legal entity, being your small business, and having it taxed only at 15.5%. And then instantly that's gone. In addition to losing all these deductions and paying a higher tax bracket, they're going to look at usually a minimum of 3 years, and they're going to apply interest and penalties. So, you're really talking at a minimum, in the tens of thousands, and we've seen cases go to the hundreds of thousands of dollars.
Oh, wow.
So literally, we're talking, you're going to lose an arm or leg here. It's going to cost you an arm and a leg, as the expression goes. But the good news is, much like a shark attack, it doesn't happen all that frequently. And unfortunately, what happens is because the magnitude is so significant that it becomes more permanent in our mind. And so we assume that the amount or the frequency of it is actually much higher than it truly is. And just like I wouldn't let the fear of sharks, even though I grew up watching Jaws, affect me from enjoying the beauty of the ocean, I don't think independent contractors should let the fear of personal service business risk eliminate the benefits of being an independent contractor. And the benefits are quite significant, especially as we know that the economy is moving more towards a world where people want to have more independence and they want to have freedom and flexibility and all the benefits that go along with that. So I think it's a great thing. I also think that you do need to be informed. I mean, just like you don't want to be going scuba diving off the coast of South Africa in a chum suit. You want to know what's going to put you at excessive risk for independent or for being deemed a personal service business as well. So be informed, but don't be afraid.
Yeah. So I guess one last question, Andrew. If I inadvertently assigned myself as a personal service business because I did my own taxes and yes, I'm a personal business, I have these services, and I didn't really understand what that meant. Is my only option to shut down that incorporation and move on and start a new incorporation, or is there some remedy available to me?
Most likely you're going to have to shut down that corporation. That corporation has now been deemed a personal service business. But what I would say is, if anyone's in that situation, talk to a lawyer and talk to an accountant and see what your opportunities are before you make any final decisions. But it's pretty unlikely you're going to be able to continue to use business as anything other than a personal service business. And the funny thing is there is actually a place for personal service businesses out there. It's not for most independent consultants, but for very senior, people that would have been otherwise employees. There is a place for a personal service business. It's just not in the independent consulting world.
Okay, great. Andrew, is there anything else that you want to add to this conversation that you think people should be aware of?
Yeah, I guess one of the other things that we should talk about is this notion of how long your contract is and how long you are with an end client and how much that puts you at risk or not. And one of the things I can tell you is there's been several cases over the history where people have been with end clients for 10, 11, 12 years and still fought and won and proven that they are truly independent contractors. However, there is sort of an increased risk of assessment, not of being determined by the courts to be a PSP, but potentially being assessed by CRA, because while it's not a criteria as far as the courts are concerned for determining whether you are or are not a PSP, it has seemed to be a criteria by CRA in their assessment process. While it's not anything that has been declared, in my personal experience, I have noticed that they do tend to target people who have been on one contract for a longer period of time. I know that a number of the big banks do have basically criteria that you can only be on contract 2 years, and then you got to take effectively a sabbatical before you come back. And I think a lot of that has been to address that issue of the additional risk that it poses for assessment, not necessarily for determination, but like I say, for assessment. So that's something to consider. The other thing I will just wrap up on are the things that can guarantee that you're not a personal service business. The only things that can really guarantee you're not a personal service business is the number of full-time employees that you have. So if you have more than 5 full-time employees, it guarantees that you're not, by definition, a personal service business. Unfortunately, realistically, that's not all that possible for most independent contractors. I know there's been a lot of discussion in the accounting world about different corporate structures where many independents come together to form one sort of umbrella corporation. And, whether there is or is not merit to that, I don't think it's necessary in the environment we're in today. That's just my personal opinion. And I'm not saying I dismiss that strategy completely. I'm just saying it's overkill for the environment we're in today. And it does bring with it its own set of risks. So things to be informed of, again. So if you're hearing buzz around that, this sort of umbrella corporation strategy, in my opinion, that's carrying a fair bit of risk in and of itself that in this day and age is unnecessary.
And additional costs as well, I'm assuming.
Yeah, additional costs as well. I mean, it all depends on how it's structured and what you're doing. But typically, once you add in an umbrella corporation, and you're probably going to have holding companies, so you've got another corporation and another cost, and then who's responsible for the bookkeeping, who's responsible for what cost. It gets a lot more complicated.
Okay, great. Well, thank you so much again, Andrew, for your expertise, and I'm sure people on here have learned a lot about the personal service business and how to protect themselves and a lot of the changes that are coming out. So we'll share both out on our website, your information on the CA for IT, as well as share out that other CRA document with those changes, just so everybody has an opportunity to review those in writing.
Excellent. And thanks again for having me. And I do apologize for having to change the timeline on you.
That's okay. We appreciate it. And we'll send out that we'll have this included out on our website as well, so people can see the video. All right. So much.
Great. Okay. Bye for now, Wendy.
Bye-bye.